Good morning and welcome to the latest of Posturite's professional webinars. It's a wonderful day out there. I'm not sure it's the same all around our country, but it's beautiful now. So just really want a bit of housekeeping just to remind you that if you have any problems listening to this webinar, we will be recording it and it will be on our website later. So please don't panic. If you've got any questions, and I'm sure this presentation will get some questions going, please use the box on the right-hand side and post your question, and I will try and get as many questions answered by Simon at the end of his presentation as we can. So really, without further ado, I want to introduce Simon to you. I've worked with Simon for several years now, and I think a very good resource to have. Simon is the director of Turnstone Law, and they're leading health and safety criminal defence lawyers. So as I say, very good to have somebody like that in your phone, I think, for when times get a little difficult. So really, Simon is going to talk about the proposed new sentencing guidelines for gross negligence manslaughter. I'm wondering really whether this is the most significant development in health and safety criminal law since 1974. So be ready to hold on to your seat. So Simon, without further ado, please let us know what you've got to say.
Thank you very much, Catherine. It's very kind of you to invite me along to speak to your Posturite audience. Yes, I think what we should do is have a vote at the end for those of you who think that this is the most significant development in health and safety criminal law since 1974. And I'll give you my suggestions for the other significant developments that you could also think about and see whether this is actually potentially a bigger one. So that's the topic. About me, just to give you a little bit on background, I started life as a medical doctor, gave that up very quickly and switched to becoming a lawyer. But in my role as a lawyer, did more and more work on safety related issues, which then became health and safety criminal defense. And I started law early 90s, and from the millennium, it's really been more or less full-time work on health and safety criminal defense. So that's defending people and organizations who are prosecuted for health and safety breaches, but also supporting you before things go wrong, not specifically with preventing accidents, that's probably your job, but putting you in a more resilient position so that if there's to reduce the chance that there's going to be a prosecution if there is an accident. So there are various legal things that I do to support you on that. So what we are going to cover here as an overview is how will the new rules fit in with the 2016 sentencing guidelines for health and safety. I'm going to talk about the new sentences of up to 18 years in jail and how are the proposed new sentences calculated. I'll comment on what this means for health and safety jail terms and also talk about what happens next. Do please, as we go along, type in your questions, and Catherine will collect them up and hopefully pose them to me and maybe stump me towards the end. So, sentencing guidelines. This is a bit confusing for some people because this isn't technically the law. Parliament, the EU, and the government make the laws, and the laws, for example, Health and Safety at Work Act, no maximum criminal fine for most of the offences, and maximum 2 years in jail, and for corporate manslaughter, maximum life imprisonment. So those are the laws, but the Sentencing Council is a group of judges, and mostly judges, and also some lawyers and a representative sitting there from the government. And what they do is they set guidance for judges to follow in all sorts of different areas as to how big the punishments should be. And then the judges have to follow those guidance if there is an applicable one. And I suspect all of you are familiar with sentencing guidelines that were produced that came into force on the 1st of February last year, 2016. And these covered Health and Safety at Work Act offences for organisations and for individuals, and they also covered corporate manslaughter. But there was one thing they didn't cover, and the reason they didn't cover is they knew it was coming later, and that was what should be the punishments for gross negligence manslaughter. And indeed, it is coming down the track. The Sentencing Council produced a draft guideline for consultation, and the guidelines are expected to come in 2018. Bear in mind, this is criminal law we're talking about, and there is no insurance for the fines, and of course not for the imprisonment. Insurers can't help you on that. I wanted to just recap a little bit on what came out last year, which is the sentencing of individuals for Health and Safety at Work Act offences, just to put in the context. So this is a maximum 2 years in jail or an unlimited fine for individuals for Health and Safety at Work Act breaches. And this is recapping on what came out. The first thing is a decision is taken on, once you've been convicted, where your culpability sits on a range from very high to low. And the point to look at is that if you are aware that what you're doing may be a breach of health and safety law, then you can very easily fall into the high and very high categories. And some people would say from the outside, well, you should never be aware that you're breaching health and safety law. But the reality, as most of you know, is that there are a range of things in your organization that you're trying to get right. And some of them are quite tricky. And there may well be a stage where you're aware that you haven't quite got it right, and you may be breaching health and safety law. But look, if that's the case, look at this definition of high culpability. Actual foresight of or willful blindness to the risk of offending, but the risk nevertheless taken. Well, if you're aware, I think you've got foresight of the risk that you're committing the offence. And it's actually not that difficult to see that you could also be bumped into the very high category because you're flagrantly disregarding or intentionally breaching. And when that translates into the sentences, and this is the stuff that came out last year, you can see how you can quite easily be in those categories that I've highlighted in yellow, which means the judge as a starting point has to give you a jail sentence. So that's where we are already, that's in place. But now I'm going to expand upon that by talking about what will be the overlay on top for if you're convicted of an offence of gross negligence manslaughter. So this document was the Sentencing Council's consultation on guideline sentences for all types of manslaughter, and as you can see, the consultation closed a week or two ago. This consultation proposed sentencing guidelines for 4 different types of manslaughter. The first 3 don't really concern us in the health and safety sphere, and it's the last one we need to focus on. Gross negligence manslaughter, the test for that is a breach of a duty of care towards the victim that causes death, and the offender's conduct was so bad as to amount to a criminal act or omission. So this is the worst criminal offence in health and safety that an individual can commit. Now, these sentencing guidelines have quite an ambitious scope. They're expected to apply to domestic abuse. So this could be child abuse or abuse within a marriage, as well as, so these are cases where someone's died because of that abuse, whether it's a baby, a child, or a spouse, and the abuser has been convicted of gross negligence manslaughter. So that's very different from what we see in the health and safety sphere. It also is expected to apply to medical gross negligence. The typical example might be an anaesthetist who gets it wrong, patient dies because the anaesthetist is not following their vital signs, and that's gross negligence causing death. But they also apply to workplace cases. Now, the aim of the Sentencing Council is to improve consistency and transparency across sentencing for different parts of the country and also for different types of offence. Sorry, different severities of offence, I should say. But to achieve something consistent, as between the domestic abuse, the medical gross negligence, and the workplace fatality, which is a tall order. And we'll talk in a bit about how I think that has led them perhaps to get things wrong. Because in a domestic abuse situation, they want to ask questions like, were you aware that your abuse could cause a death? And that's quite a tricky situation in the case of child neglect. Not so easy necessarily to answer. Whereas in the workplace case, it's very often kind of, well, that's just, you are aware. Certainly you're an anaesthetist. Of course, any doctor aware that if they're grossly negligent, they could cause a death. So let's think of the other aims. So what that means is they want to use generic factors for culpability and sentencing that apply across all of these different types of gross negligence manslaughter. So far as workplace is concerned, sorry, yes, Catherine, go on.
I was just going to interject. Can I just say, is this aimed at directors or managers or anybody who in the chain of command? Where is this aimed at?
Yeah, that's a good question. It's sort of aimed at the senior people, but there's absolutely no reason why it can't be any person from top to bottom within an organization who's been grossly negligent. So if you think about it, of course it could be a director, but equally it could be a co-worker who does something grossly negligent causing a death. That could certainly be the case. So yeah, all bets are off. It's anyone. It's not like the senior manager offence, the director offence in the Health and Safety at Work Act.
Oh, okay.
I think that answers that one.
Thank you.
So what the Sentencing Council said is they do want to increase the sentences where, and this is their sort of the evil person they want to attack, an employer who's had a long-standing utter disregard for the safety of employees and is motivated by cost cutting. But there may be other analogous factual scenarios where sentences would also rise. So they certainly want sentences to rise for this sort of case. Now, I'm going to do a worked example, and I'd like you all, the audience, to kind of think, could this be me, and what sort of example in my workplace could this be for me or one of my colleagues? So you've been aware for more than a few weeks of a poorly controlled safety risk at your organization that could cause a fatality. It falls within your responsibility in the health and safety policy. You've been putting off sorting it because there's funding pressure, and then there's a fatal accident. You're put through a 3-week trial at the Old Bailey, and you've been convicted of gross negligence manslaughter. So these are the ingredients. This is a dreadful scenario that's happened. You were aware of this poorly controlled risk. It was within your responsibility, and you knew it could cause a fatality, and there was a funding aspect to your breach. So then what happens? And these are the draft proposed guidelines for gross negligence manslaughter. Rather familiar stuff here. We've got culpability factors, and along the left you can see they range from very high to lower culpability. Let's focus on the high culpability factors in the middle of the screen, the 3 I've highlighted. So if these things apply, this is indicative of high culpability. The negligent conduct was motivated by financial gain or the avoidance of cost. Well, that's immediately a red flag. And in our example, that was one of the factors. The negligent conduct persisted over a long period of time. Well, it's not very long here. Weeks or months is enough. So you've persisted in this for weeks or months, and there was an element of motivation for financial gain. The offender was clearly aware of the risk of death arising from the offender's negligent conduct. Well, yes, you are aware. So those 3 factors apply in our example. That means you're quite likely to fall in high culpability, but pause a minute, look above. Excuse me. If you have a combination of the culpability B factors, that can be enough to take you into the very high culpability category. So for the example I've given, you're either going to end up in high or very high culpability. Now, the problem is, and I've made this very clear in the consultation response that I've orchestrated, in the health and safety context, your failing is most likely to be one where you know you've got a health and safety duty, and if you get it wrong, someone could die. In fact, you'd be a more serious offender if you didn't know that. And most likely, your offence is one of omission. You should have done something to fix something. And offences of omission could tend very easily and normally to last weeks or months. Indeed, an offence of omission that causes a death that has only lasted a day is probably a more serious omission than an omission that lasts weeks or months before it causes death. But hey-ho, here we are. If we're in the workplace setting, we're trying, but we omit to do what we should have done, and it lasts weeks or months, and we're aware there's a risk of death, suddenly we're sucked into high culpability, and if there's an added ingredient of avoidance of cost, we're really getting in trouble, and we could easily be in very high culpability. So what does this mean? The next slide translates this into the recommended jail sentences for those who fit into the categories. And now, just for those of you who are thinking, oh, wasn't there a harm category like we had in the other sentencing guidelines? And no, there isn't, because the harm here is always death. There's been a death. So if we were, I'm going to go back a slide, if we were in categories A or B, we see the starting points. So for B, which I think is going to be the norm for workplace gross negligence manslaughter in these guidelines, you start with 8 years in jail. And then if there are factors in your favor or against you, the judge can drop it to 6 years or increase it to 12 years. And if you were in the very high culpability, the starting point would be 12, and as you see, it could go up to 18 years in jail. Now, the point I want to make, and I hope I'm starting to make it, is how easily you could fall into one of these very long jail terms, and how difficult it will be to, if you are convicted of gross negligence manslaughter, to get down to those 2 to 4 year jail terms which have been the norm up to now. So I think what this means is people will be facing some very seriously long jail terms, which personally I think are totally pointless. I think if you are a very seriously culpable offender in the workplace setting, causing someone's death by your gross negligence, I think personally those very serious cases could and should well lead to 4 years in jail. But once you start doubling, trebling, even going up to 18 years in jail, I don't have any remote concept of what the point is of those extra year jail terms. That's my personal view. Now, the other things that are taken into account to move up and down on those scales within the ability the judge has, one of them I've got here, there's aggravating and mitigating factors. One of them, an aggravating factor, is blame wrongly placed on others. That's a really tricky one, because if you want to fight at trial to avoid going to jail for 12 years, you're almost certainly going to have to show that your breach was relatively unimportant to other people's breaches. So you're almost certainly going to have to show that other people were to blame. And then if you get convicted, the judge is going to say, oh, well, you've wrongly placed blame on others. And then that's a factor that shoots you further up the scale. Not good. And equally, one of the factors that could take you down the scale is remorse. But you'll have struggled to show remorse before being convicted if you're actually trying to fight at trial. So what happens? Yes, Catherine.
So there's a few. There's just something buzzing around my head. I mean, I'm thinking Grenfell Tower here. I mean, is this going to have a? Does it apply in this case, or could it apply in this case?
Could certainly apply, and I'm quite sure that the victims and the victims' groups and their lawyers are trying very, very hard to encourage the authorities to charge individuals at the various organizations where culpability might be shown, and we don't need to rehearse that now, but absolutely sure they want this sort of thing to apply.
Because I'm
definitely.
thinking, blaming others, there are so many parties involved. I would imagine that that's going to, as you were saying, when you're trying to defend something, that's surely going to be one of the things that you're going to be looking at is it wasn't me, it was them.
Yes, definitely. And as we'll also discuss, this is retrospective. In fact, I'll come to that. So what happens next? The consultation is closed. Um, I'm on the committee of the Health and Safety Lawyers Association, the HSLA, and in that capacity, I led a our own surveys and meetings and our own mini consultation and drafted a response to the Sentencing Council, which was highly critical of their proposals. I think they've gone way over the top. I think in trying to bunch workplace offenders with domestic abuse offenders, they've garbled up the culpability factors and put things in that are really simply ordinary, if we could have such a thing, ordinary ingredients of a gross negligence manslaughter offence. And they've used those things for a health and safety setting, which will shoot you up the scale in a very unfair way. So, and in fact, I should point out, for those of you, if you are interested, if you send me an email, and my email address is at the beginning of the slide presentation, if you send me an email, I'd be happy to send you the Turnstone Law response that I drafted to this consultation. So it's the response that I have submitted. Now, the plan is that this stuff comes into force towards the end of next year. So you might say, oh, we've got a bit of a breather. Well, in a sense you do, but it's retrospective. What this means is, well, why is it retrospective? If you commit an offence today, someone dies today, or in fact last month, then the investigation is likely to take a year or two or three or four before you end up being tried or being convicted of gross negligence manslaughter. So the chances are that if you're in breach today, which causes a death tomorrow, the chances are you won't be sentenced until 2019 at the earliest, really, which means this will be enforced to guide the judge as to how long you should be sent to jail for. So in that sense, it is entirely retrospective. Now, is this the most significant health and safety law development since 1974, which was the year of the Health and Safety at Work Act? Well, I've got some other suggestions for very significant developments. One was corporate manslaughter introduction. Now, although that's easily viewed as a very serious, significant development, most of us have seen that it hasn't really changed much. And with the recent sentencing changes last year, it becomes less important to have a conviction for corporate manslaughter. There haven't been any convictions yet of the very large companies that we were waiting for. So I don't think that is terribly significant. There was the 2-year jail terms for ordinary health and safety offences. That was pretty significant. And then there was last year's sentencing guidelines, which increased the levels of fines for health and safety offences, and jail terms became a lower threshold before they were dished out. So those are my other candidates. But do you think possible jail of 18 years and probable jail of 8 to 12 years for health and safety offences causing death, do you think that is actually more significant than anything else? Well, we wait and see. We wait and see whether this actually comes in, because there's a chance the Sentencing Council could listen to my lobbying. I don't know how high to put that chance. I think the arguments against their proposals are very strong, but in the past they've barely ever changed anything from their draft, so we have to wait and see on that. What can we do? Well, I suppose the best thing we can do is to see this as both a challenge and an opportunity, and I think use it as a spur to improve performance and legal resilience. So, for example, and this is what I've been doing recently, incorporate this into training for senior management. I mean, I give training to senior management on essentials of health and safety law, but I can use this as one of the tools to help them understand how serious this is, how they can personally get into trouble, and then use that as the hook to explain to them what their duties are and that they personally need to comply with those duties to stay out of jail. So we can use it as a tool, and I do that both with face-to-face training for boards of directors, but also with a computer-based training that I've drafted, which works quite well for that. These are really my health and safety legal tips to reduce the chance that you get prosecuted if there's an accident. So the next one is look at your health and safety policies. You probably haven't had them reviewed by someone like me to iron out the common hostages to fortune. They almost invariably have wording that creates very onerous duties for individuals, which are often impossible to fulfill and needs to be gently ironed out. Things like who should sign the policy statement, in what capacity they should sign, and what roles and responsibilities should be drafted for them. These are rather subtle points which, when I review them, there are almost always comments to make to reduce some of the hostages to fortune. And then another legal activity or legal procedure to reduce the chance of prosecution is that your internal investigation reports after an accident can very often be dynamite in the hands of a prosecutor. And if we introduce with you a procedure to seek legal privilege protection over these reports, then we don't have to hand them over to the HSE, the police, or the civil compensation claimant. So there are a variety of legal steps to reduce the likelihood of prosecution in the event of an accident, and those are worth thinking about. So that's enough from me for the moment. If you've got any questions, I hope there have been some questions. I don't know, Catherine, how are we getting on with those?
I think questions are a bit slow, but they often are until we get to the end and it starts, juices start flowing, as it were. I mean, I've got a few. Oh, here they start to come through, but I'm afraid I'm getting in first. I suppose quite pertinent. My daughter's actually up in Scotland. Do these apply in Scotland?
Well, thanks. That's a good question. The answer is yes and no. There you are. There's a good lawyer answer for you. Well, this is the Sentencing Council for England and Wales. So technically, these apply in England and Wales, and they are binding on any judge who is giving out a sentence in England and Wales. However, the judges in Scotland are very mindful of the English sentencing guidelines, will certainly take them into account unless or until they have their own sentencing guidelines. And if they do, those ones will pretty well follow what we've got. So, and actually, funnily enough, you might say, oh, this is very draconian. Surely in Scotland they won't be quite so bad. Actually, I've got news for you. The Scottish judges don't like to be outdone by the English judges, and they don't like to think that they're a soft option. So if anything, their tendency is to be stricter. So I think you should regard these as the same sort of thing would probably apply in Scotland and indeed in Northern Ireland.
Right. Okay. Now, actually, I've had another question that she's along the same lines that I've just written down. Would this apply to road deaths caused by gross negligence of drivers? I was going to say that was one of the ones that really flagged to me.
Great question. Great question. The simple answer, well, it would apply to a road death if you were charged with gross negligence manslaughter, rather than being charged with one of the other death by careless driving, death by dangerous driving offences. But of course the difference is, the subtle difference is that this could be used, those offences could only be used against the driver of the vehicle. These offences could be used against the manager of the driver of the vehicle. So you send someone out on a long, one of your employees, you send them out on a trek for hours and hours of driving, knowing that they're tired, and you say you've just got to do it, or they're doing overtime, or they're doing a project that involves lots of hours of work and driving, and your gross negligence is the thing that's caused the road death, then this would be the one that would be used against you.
I think that's quite sobering thought, actually. This is an interesting one. Would these offences be investigated by the police and then prosecuted by the CPS or the HSE? Who would actually do the investigation and use this?
This is the former. It's investigated by the police, prosecuted by the Crown Prosecution Service, with support and assistance from the HSE, but the HSE are not in the forefront.
Oh, that's quite interesting. That mixes it up a wee bit. And on that front, what about appeals? Can you appeal against these things if they came in? You know, if you felt that it was too harsh, who would do that?
Yeah, yes, you can appeal against sentence. So this would be, so you've been convicted, and then the judge goes through this list and sends you to jail for 12 years. You can appeal against your sentence, and then you go to the Court of Appeal. But you've got to have an argument there. And one argument that doesn't work is the judge was following the guidelines. The guidelines are horribly unfair. That doesn't work because these are the guidelines. The Court of Appeal have to follow them as well. So it doesn't necessarily help you.
And where is the Court of Appeal? Is that the High Court? What's the final?
The Criminal Court of Appeal, and then after that the Supreme Court. But it doesn't get anyone anywhere. Because all those courts have to follow the guidelines. Of course, if you say, the guidelines weren't followed properly, following the guidelines I should have been highly culpable, not very highly culpable, of course you can argue that. But what you can't say is, following the guidelines, it led to me getting a starting point of 12 years. That's just not fair. The starting point should be 6 years for my type of offence. It doesn't. You won't get away with that.
Right. Another good question here. If it's investigated by the police and prosecution, where's the HSE role in the Riddle deaths? How does Riddle deaths fit in with this?
You report the death on Riddle. The police and HSE. I'm not quite sure exactly who did. Well, you probably very usually you'll be dialing 999. And calling an ambulance, and I'm not quite sure how the police find out, but they're going to arrive very soon anyway when there's a death. So the police, there's then a memorandum of understanding between the police and the HSE over how they should deal with accidents following a death and the investigation that follows. And to cut it short, what it says is the police go first, investigating potential gross negligence manslaughter. And that could take days, weeks, months, or potentially years. And then only when they've decided that they're not investigating gross negligence manslaughter, they pass it on, they pass primacy on to the health and safety executive. But, or the local authority, as the case may be for some of these. But even though that primacy is passed on, the reality is they do work together, and you might find yourself being interviewed, and although the police may be leading the interview, there'll be an HSE inspector next to them, nudging them and feeding them a list of questions.
Right. And I suppose that comes back to what you were saying about looking at your policies and things, because one would need to be very careful what one wrote in one's Riddle submission, because obviously that would potentially
Riddle submissions can get you into trouble, but also the policies get you into trouble, because when they're interviewing you or your director and they want to establish a breach of duty, the first thing is, what's your duty? And the first way to answer that is to say, let's look at the policies. Here you are, you're the transport director. It says in your policy, the transport director will ensure that all vehicles are adequately maintained. Okay. Do you accept, Mr. Smith, that is your duty? And Mr. Smith says, oh, yes, I suppose so. And then the policeman says, well, do you believe this vehicle was adequately maintained? And he says, well, I suppose it wasn't. So you accept, do you, that you've breached your duty to adequately maintain this vehicle? Yes. Right. Well, then you're sunk. And what I would want to do is tweak that description so that it might say something like the transport director will seek to ensure that all vehicles are adequately maintained. So then when he's asked, so do you accept it's your duty to seek to ensure that all vehicles are adequately maintained? He says, yes. And what did you do? Well, I relied upon my assistant transport director. So you've got a better chance of staying out of jail if you're, and we put it the other way, the wording can get you into jail. You need sensible, balanced wording in these policies. You do want to allocate roles. You do want to give people responsibility. But as a lawyer with experience in this, I can see where sometimes the wording is over exuberant and just needs to be slightly calmed, and yet calming it without reducing the effectiveness of everyone knowing that they've got a duty to perform and what they ought to be doing.
Yes,
it's a difficult job.
I think so. I'll just certainly go back and look at mine and say that. Now, I'm afraid we're running out of time. I've just got one last question, Simon, and I think it's quite interesting. Do you think that the police and CPS will preferentially prosecute these offences over the corporate manslaughter and corporate homicide offences if it goes ahead as is?
Well, that's really interesting. I've no doubt that the HSE have treated with some relish the new toys in the closet, that they can inflict some very serious penalties by prosecuting with the last set of sentencing guidelines. I think this will be something that will make it more interesting for a policeman investigating, a police officer investigating, and also for Crown Prosecution Service staff pushing forward prosecutions. So I don't quite know. Maybe it would be unfair to say that this will influence them, and it shouldn't. But having said that, I think it will. What I predict will happen if this comes through, there are going to be some very alarmingly large criminal jail terms for health and safety, which will, I think, I'm now answering my question, I think which will have a huge impact on the whole health and safety world. It could create a backlash against the health and safety and HSE world. You know, this is health and safety gone mad, people might say. I think it will be a very interesting debate.
Brilliant. Well, I think on that, Simon, we're going to have to leave it. So can I thank you very much? I could talk about this all day, and I'm sure you could too, but thank you very much for that, and I shall catch up with you very soon. And for the rest of our listeners, again, thank you for joining us. And just to remind you that our next webinar is going to be on Friday the 17th of November, and I'm going to be in discussion with Jason Chadwick talking about health screening and well-being. So please join us then and enjoy your weekend, and thank you everyone. Okay, goodbye now.